Okay, I have some technical difficulties. Excuse me for that, but let's continue on with the court session that we have to have out in the public realm for public awareness, individual awareness, most definitely employee awareness, for certain people of color awareness, and absolutely if you are a Black person, awareness, right? Because discrimination is real, okay? Retaliation is real in the employment setting, in the workplace. Yes, it is, okay? And it is just sickening, and it's egregious, atrocious, and outrageous, the extent that individuals will go to ensure that you're silenced, and that your rights continue to be revoked. I mean, at all levels, and that is inclusive of the judicial system. So there's a lot of underlying and complex fish bones to this entire issue that I have said before. I now need the public to have the awareness, because Chris Brown of Columbus, Ohio, Franklin County Court of Common Pleas willfully, deliberately, and intentionally deprived all of my rights as a human being. So I have no life, no liberty, no property, no pursuit of happiness. All of my civil, human, US and Ohio constitutional rights have been revoked from me. All right. So I am a slave, pretty much. And Chris Brown and all of these individuals that are actually lawyers have participated in conspiracy to commit grand theft of my property. And they're all my slave masters, pretty much, in a shell, essentially. So basically, we'll jump right on into it. If you looked at any of my other videos, you'll see that I have said in Columbus, Ohio, Franklin County Court of Common Pleas, case 22CV007866. It is an improper interpleader. It is a spun narrative of half-truths, a web of lies, in the best interest of the attorneys for CVS Health, CVS Health Corporation, CVS Health Pharmacy, Aetna Resources LLC, which are subsidiaries of CVS Health Corporation. There's a lot of wrongdoing. There's a lot of cahoots and corruption, and collusion and cover up. And it's because the culprits, the real true criminals and menaces to societies are they actually lawyers? Yeah, and so these lawyers have teamed up and gotten cahoots, and they strategized a plan, and they devised a way to actually steal my money on purpose, and they cover it up by way of utilization of legal expertise and knowledge and legalese and case law and so on and so forth to really fraud the court, fraud the people, taxpayers, voters, and so on and so forth, the community as a whole, with their frivolous and misconduct by way of the judicial system. And they're continuing to do it. And they just keep on at every effort, refusing to take responsibility. And they just don't want to be caught. And they're trying to wiggle it out they keep utilizing these courts and shit to do it. But yeah, you'll be able to see if you pay attention, but they really don't want anyone to come in with transparent eyes, or, just a clear lens and look at both sides of the situation. It's very complex. It involves EEOC. It involves Title V11 Civil Rights Act of 1964, specific to discrimination grounded in race and disability. And it also involves Ohio Civil Rights Commission's charges and an OSHA whistleblower retaliation charge as well. And the EEOC charge itself ultimately resulted in a settlement after EEOC initially gave a right to sue in one charge where I continue to work at the entity. And of course, once you start complaining of retaliation or talking about race and discrimination and all this type of stuff, they start lying on you and doing all this. Well, less than 14 days after serving these individuals and the entity as a whole as the vicariously responsible or liable employer of the employees, I was fired. So less than 14 days. So they were served a federal summons on July the 8th, and I was fired July the 15th. And so that's just how quickly there was a problem brewing with my performance, and all of a sudden I had violated policy, and boom, you're fired. Yeah, but the Ohio Ohio Department of Job and Family Services actually did do an investigation, which they're a governmental agency that's third-party, non-biased. They look at things objectively, and they did determine that I was terminated without cause, and they did allow my benefits, of course. Okay, so essentially, Aetna Resources LLC, CVS Health Corporation, and its employees that led to the filing of these claims of discrimination in the workplace, they're not an alleged tortfeasor. They're an actual tortfeasor. Okay, an actual outside governmental state of Ohio agency determined that already. Okay, yeah, so let's go with that. Yeah, they did agree to pay me a settlement and a confidential amount in full, in total, solely and exclusively, directly to me. And they did know about a fee dispute between myself and Spitz Law Firm. And they did initially write up an agreement, a settlement agreement that allocated $15,000 to Spitz. And they were caught doing this because actually it was EEOC Salvador Lopez, mediator, and Richard Diageo, Littner Mendelson PC, counsel for CVS Health, Aetna Resources, CVS Health Pharmacy, and whatever else they want to call themselves, in cahoots to ensure that Spitz was to get some types of fees where everyone that's privy to this information, everyone that is listed as a party, Littner Mendelson PC, CVS Corporation, CVS Health Pharmacy, Aetna Resource LLC, Spitz Law Firm, everybody. The court itself, Chris Brown, Franklin County Court of Common Pleas, Franklin County Clerk, Sherrod Brown, Joyce Beatty, everybody in the world knows there is no lien. There's no lien, there's no attorney lien, there's no charging lien, there's no fund that has ever been created that a lien could even attach to. Nothing, absolutely nothing. Spitz Law Firm has no actual work. They stole all my pro se work. Yeah, and pass it off as their own, but now they're trying to flip it up as if like we reviewed over 200 documents. Well, just reviewing documents of a pro se work product, does not entitle you to $15,028 of that person's equitable property at all. Okay, so Spitz Law Firm asserted that they were that they had a charging lien, attorney lien. They don't have that at all. It doesn't exist. There's no notice that's attached. No motion was ever filed in any court. There's nothing attached to any settlement whatsoever. Not one that they claim they negotiated and they got, which they have no settlement whatsoever that has any type of signatures, nor can they prove any type of actual work, dedication, or any fruits that they, of their own labor. They should not be reaping any fruits of my labor because they can't prove any of their own labor, blood, sweat, and tears that they worked on my behalf as a client of theirs, by pouring anything commensurate to their level of education into any settlement, not the one that they claim. Spitz Law Firm claims that they've been working on a settlement on my behalf, and they were constantly in contact with me and negotiating back and forth. But to date, I still don't know why $80,000 demand for settlement that Greg Schumacher called me back in July of 2022, told me he was sending over to Littner Mendelson. I still don't know why they never accepted that. I never got any information back post that to rebut or refute, but yet they keep claiming that they regularly communicate. It's all lies. So what it actually is, and I did figure it out, and sometimes it takes you time to figure out wrongdoings of individuals that equate to misconduct, but I finally did figure it out. What they do is they utilize their authority settlement agreement to go and make settlements for themselves without ever communicating with the actual employee who's been wronged or allowing them opportunity to rebut and refute, but then they utilize that as their way to get over in court. And they got Chris Brown to help them do it. These people are liars, folks. Okay? These people are criminals. Do you understand me? Well, anyways, let's just bypass all of that. I give all the details in other videos that are actually on YouTube. Or I have one main video that goes into the details of all the background. And just for your information, if you're interested, I think really any law educator, professor, you should really have your students checking out this case, because it's all encompassing of a lot of different things. It's malpractice, it's negligence, it's actually grand theft involved. It's also breach of fiduciary duty. It's also, it talks about it in a pleader, but at least your students will be able to see what not to do, and to never file an improper in a pleader, which this is, and to not participate in frivolous conduct, not to participate in misrepresentation, all right, not to, ultimately not have integrity, because students, if you don't have integrity, you're not a lawyer. A lawyer with no integrity is not a lawyer at all, right? And that's what someone stated. Someone quoted that, and it's absolutely true. And all these individuals that I'm talking about in here are lawyers, all right? The judge used to be a lawyer. Each and every one of these individuals have no integrity, and they should not be lawyers. They should all be disbarred, and Chris Brown should be off the bench, right? Also, keep an eye on Michael Holbrook, because I put a motion in to have the EEOC MSA agreement unsealed, which it must be unsealed for anybody to get a true understanding of the totality of the situation and to understand what the underlying agreement, the settlement states. Okay, so Spitz Law Firm got paid $15,028 of, which is 40% of what the settlement that they said that they got, which was $37,500. Okay, they did not get that settlement on my behalf and in my best interest at all. And I have the right to not sign. I have the right to decide that I don't want to be bothered with that type of shit, especially when I figured out, and I was yeah, and rightly so, I fired them because I figured out what they're doing. They try to get you to not, for you to think that you don't have any rights because you signed a authority, that then you have to go along with whatever the fuck they said when you figure out what they did. And no, you do not. No, you do not. Okay, so what it is at this point, Spitz Law Firm, they only are a creditor and they only can assert an indebtedness. And if they genuinely feel as if they have some type of a right to any type of payment for services that they render, just like any creditor, they have to illustrate and demonstrate what those services are. And they have to have a starting point on those calculations and how they came up with those fees that equate to $15,028. The complication for them is they are not going to be able to do it because they don't have any actual work. Do you understand what I'm telling you? No, they don't. Now, if they want to charge for time spent on the telephone negotiating on their own behalf or their own settlement, okay, they can say that, but even that is not my responsibility as a client to pay for, because they weren't acting in my best interest and whatever efforts over the telephone they were doing and negotiating. Right. I mean, you told me you were negotiating, so I'm aware you were negotiating, but you weren't negotiating in my best interest. All right. I don't know what you were doing, but I didn't get any feedback on anything or opportunity to basically rebut or refute. So Trisha Breedlove states that she was negotiating on the merit of the case. How? All right. And then they tried to also lie. Brian Spitz just recently put in an appellee reply to my brief as the appellant in Ohio Court of Appeals, 10th District, 23-670/23-AP671, which respectively is associated directly with the trial court case 22CV007866, the improper interpleader, and then the complaint that I filed against Spitz Law Firm, and they cross-claimed, right? Because that's what an interpleader usually does. It just puts you in there to fight against each other, but it's improper interpleader anyway. It should have never been filed, period. But that was part of their plan. That's their strategy. And they just were hoping that they wouldn't get caught and that I wouldn't know anything about what they were doing. So now the cat's out the bag. So I'm just curious to see how they're going to dig their way out of that. Each and every one of these individuals needs to be disbarred and they need to be arrested. And they need to be in jail. Their faces should be plattered all over the internet and social media and all news outlets, just like yours would if you had robbed someone of $15,028. Yeah. Or you went filing bullshit in courts and lying and all this type of stuff. Okay, now this is judicial activity, and the public and the people, taxpayers and voters, have a right to know what's going on, because this is employment, and this has to do with discrimination, has to do with federal law, has to do with employee rights and protections, and on those types of things, the Constitution, and a lot of different things. And you have a right to know what's going on, and the courts need to be transparent, because the courts are utilizing your taxpayer dollars. It's misuse, it's waste, it's fraud. And these lawyers did it, and they did it on purpose, and it still continues. This law firm currently has $15,028 of my equitable property in hand illegally. Spitz is a creditor. All right. No creditor has a right to just go and debit your income for any amount of money. Definitely not $15,028, and just take it. I don't give a fuck if it was a real summary judgment that was true. You still just can't go in somebody's bank account unauthorized and take out however much you want of their fucking money and claim it to be your own and act like, okay, that's okay. No. So Spitz received a check from CVS Health Pharmacy, Inc., who is not named in any type of employment claim. They're not a respondent in any type of EEOC or civil rights of Ohio commission charge or the whistleblower OSHA charge, nothing like that. So the settlement that exists involves Aetna Resources LLC. And if you know anything about settlements, it's typically the insurance company that pays out settlements. So why the fuck did CVS Health Pharmacy, Inc. pay Spitz Law Firm directly $15,028 and try to trick the IRS and the world and everybody else into believing that they have a obligation to Spitz Law Firm, as if Spitz Law Firm is a vendor or a customer of theirs, and they gave them a remittance advice. They created on 11/3 of 2023, and they issued a check on 11/7/2023 for $15,028 as if they owed it directly to Spitz Law Firm as a customer or vendor or something like that. Yeah, under CVS Pharmacy, Inc., who has a different EIN number than Aetna Resources LLC, who Aetna Resources LLC, under their EIN, paid me my past wages from their wrongful termination, right? And then they also paid me the other part of the settlement, which is the pain and suffering that you get that the insurance has to pay outright. That was paid by Aetna Inc.'s insurance, Hartford. All right, so what is really going on here, people? What is really going on here? How does CVS Health Pharmacy all of a sudden issue $15,000 equitable property that was due to me, balance of an EEOC settlement, confidential settlement amount that was due actually, as it clearly illustrates in the settlement agreement and the terms, that all of it, inclusive of the $15,028, was to be paid to me directly in full, entire sum. It literally says that with all those terms I just stated. Okay, within 30 days of October the 18th of 2022. And Karen Gaster of Aetna Resources LLC CVS, she signed off on that. All right, and Mendelson PC, attorney, counsels for CVS Health and Aetna Resources, CVS Health Pharmacy, and so on and so forth. Everybody knows exactly how that agreement and the general release and everything reads. Everybody knows that it's Richard Diageo that caused his own issue and his own liability and the liability of CVS Health, CVS Pharmacy, and Resources LLC, and anybody else that's involved in even this. So now Richard Diageo has caused each and every person that's participating in this conspiracy to commit grand theft by way of a money heist scheme to now all go down with him and lose their livelihood and be locked up in jail as well, because he didn't want to take responsibility for going to tell Spitz Law Firm that, listen, I got $15,000 for you in an express settlement agreement, but yet he actually did not. At the end of the day, he willfully avoided that agreement, right? When I stated, what exactly are you guys doing? You know, there's no lien that exists. There's no separate action. There's nothing. That's just a creditor asserting an indebtedness. You cannot put that in a settlement agreement. He's not entitled to that. He has to go and sue me if he feels that he's done some type of service, or his corporation or any other attorney, that they need to be paid for. They have to bring their actual work in and prove it and get paid. And that's a fair thing to do. I don't have no complication or issue with paying you for services that you rendered while you were hired and so-called working to negotiate, but you have to prove that. And you have to prove it to a non-biased person that's kind of looking just objectively at things, okay? And they did not do that. All right, so they had to figure out a way to get them $15,028, which is actually from my labor. Okay, that's the fruits of my labor in my own settlement, and all my claims and all my charges. In fact, I filed every single claim and every single charge. I did every single motion, every single pleading. All right, I did every single brief. I did every single investigation. I did the discovery. I did pre-litigation research. I ripped and ran up and down the street making copies and doing mailings and all this type of stuff. I use my postage. I use my money. I use my gasoline. All right, my time. And it's my blood, sweat, and tears. And I am the victim of race discrimination and disability discrimination, okay? But what Spitz Law Firm is doing, and all of these people are doing, they are utilizing me as a scapegoat, and they're just continuing to intentionally and deliberately and willfully, retaliate. And it's just further discrimination. And they feel that they can do it because I'm Black, all right? This is a racial thing. This is race and this is slavery. And they took away all my rights. They took away my voice. They took away my entire life, my property, everything. They did it on purpose, and they're still lying about it. Okay, this is slavery. Stop stop being, thinking that this could never happen, because it just did. And so therefore, I don't give a fuck about shit. I'm never going to stop talking about this. I am not anybody's slave, and none of these people own me, but they feel that they do. And they feel like they don't have to uphold any type of constitution or how it reads, because they don't think that Black people, okay, at all are people. You're not the person. You're not the individual in which the U.S. Constitution or state constitution or anything that protects your rights. You're not involved in that, Black people. All right. You're not involved in it. And that's how they look at it too. So that's why they feel like they could just do whatever, because I'm really not what the title V11 Civil Rights Act of 1964 is really speaking of when it says that you're not allowed to discriminate against. Okay. That's how they feel. They feel like, well, that doesn't mean Black people. That's everybody else and every other race and every other colored person, perhaps, but it's not you Blacks. All right. Obviously. Okay. So we're going to let you know, public out here. So just be careful, just be cautious, because it can and it will, and it probably already has happened to other people, and no one stepped in, nobody did anything, and that individual didn't know how to stand up for themselves and speak up and speak out, or learn and know the legalese and have some wherewithal of their very own to be able to fight and battle against this type of shit. But I mean, these lawyers, they can go and thank other colleagues within their profession for the knowledge that I do have. They can go and thank the individuals and the colleagues in their profession that are actually upstanding and great individuals that provided this level of expertise and insight into the legal realm that I've been provided through Capital University Law School in Columbus, Ohio, with very good attorneys, most all being female, one being an actual nurse, in fact. And a couple of them telling us, you can't practice law, but however, you can defend yourself. So if you ever have anything that you have to do in a court, you will definitely be a spitfire for yourself and advocating for yourself and what we're teaching you here. All right. And it was done deliberately. These women did that deliberately. They don't care anything about color or nothing else. It's just about whatever the law stands for. I mean, it doesn't even matter about any of that to most people about race and all this. They really just want to be fair and uphold the law, and they don't want to be biased, and they don't want to be prejudiced, and they want to be impartial and want things to just be looked at objectively. But these people do not, and these are the bad apples, and they're being exposed and exposed for a reason. This is a large chunk of the bad apple. So this is great. And I said, thank you, Jesus, for the revelation. And, even though I've been dragged through the mud and they're throwing me into litigation, the purpose of a settlement actually is to not litigate. And actually, Alex Frondorf did this on purpose. Like you started a whole fight in a fucking piece of shit interpleader, which isn't even supposed to take long or anything. But this isn't a real interpleader. And then Chris Brown's dumbass, he is a piece of shit. He should not be a judge. It's no telling how many people's rights he's revoked. And he doesn't like Blacks. So you need to go back and look at every single case that he had where he ever locked up any Black person that's so-called a criminal, because he lied and he made up shit 9 times out of 10, guaranteed. And what the tactic is they sit up there and they do summary judgments and they revoke your entire right. They make it seem like you don't have a case, that your case has no merit whatsoever. There's no triable material facts that exist that they, even know about, knowing that all along you done told all this shit that gives you the right to come into court and be able to call people, to be able to confront individuals, to cross-examine individuals, to have witnesses come in, to get expert witnesses and all of this, and have, non-biased and non-prejudiced and impartial individuals looking at your case. You can get a jury demand. You can have people out here that don't know you or the opposing party, and they're looking at things just for what it is from the surface, and they're going to make a fair decision. I put a jury demand on this case, and Chris Brown overlooked it. He overlooked every single motion from November the 9th of 2022 all the way until October 27th of 2023, when his staff attorney, Jacqueline Bajas, sent out an email in the that she established to avoid ex parte communication, which actually attaches to this fucking case record. And the Ohio 10th Appeals Court won't allow it to be put into the court, even though it does contain material facts as well. And it does actually serve as evidence to substantiate every other thing that I'm saying about these individuals that keep participating in the crime. They keep ignoring my outreaches for my property and all of this. And they know exactly what they're doing. Okay. Brian Spitz offered me $1,000 to drop all my claims, $1,000 of my fucking money that he shouldn't have in his hand any damn way. Okay. They're all in cahoots. It's collusion. It's corruption. All right. And I'll never stop talking about it. They should have never done this. This is ridiculous. And it's still continuing. And actually, there's a mandatory reporting duty of these individuals in the judicial system to have the awareness of this felony that has taken place. And none of them are reporting any fucking thing. They're not doing anything about it. And I'll never shut the fuck up. And that's why I put it in this shit too. Okay. So I'm getting ready to sue each and every one of them. I'm waiting to see who these judges are and what their opinions are as well. Because if you don't report this felony and have these people prosecuted, okay, this needs investigated. All right. I need my money and I need everything that's due to me. And I need to be compensated for my severe harms by each and every individual and each and every entity that has lied. Okay. Period. All right. These are criminals. Okay. So let's get into it. This is the reply. I'm not no fucking lawyer. I don't have know what I'm doing, but I have to do the best that I can. These people stole my livelihood. They snatched my job away. I wasn't doing shit but trying to serve people in vulnerable populations and individuals with health issues and concerns, trying to be well. I'm trying to optimize their health outcomes and provide them with community resources and supportive linkages and things like that to ensure that their social determinants don't remain unmet, doing the very best I can to, work effectively and efficiently on a damn job as an actual change agent and a leader. Okay. And I'm highly educated. Okay. I'm MBA prepared. I'm a legal nurse. I'm a life care planner. All right. I'm a nurse educator. Okay. I'm a doctor of nursing practice candidate. Like, I'm just like, motherfuckers, leave me alone, damn it. I'm just trying to live my fucking life and help people out here. I'm not bothering anybody. Why do these people keep bothering me? These are devils and these are demons. These are witches and these are warlocks. In the name of Jesus, bring a wrath on all of them. Bind them all up and send them to hell. Thank you, Jesus. Okay. Chain them down with chains and feathers. Never let them come back and harm another person ever. And any of them that are still out here, every single harm that they put on anybody out here, Heavenly Father, in the name of Jesus, reverse it all back on them. 100 times fold, if it be your will, in the name of Jesus. Bring a wrath on them, their family, their children, each and every person that they love, Lord God, just like how they've done everyone else. Karma is a whole bitch, okay? And it's coming back on you. Trust me, don't mess with God's people, honey. I can't help I'm a chosen person. I didn't ask for that. I didn't ask for this, okay? This is just what I have to do. It's my mission. I'm going to carry it out. But I will tell you right now, you'll never have the victory over me. And that's what they just tried to do. And that's what they do all the time in Franklin County Court of Common Pleas in Columbus, Ohio. It's not only Chris Brown, it's Karen Phipps as well. They revoke rights. They are guilty of deprivation of rights under color of law. And what they do is they find summary judgments where they know that true material facts, tribal facts actually exist. They know it. And then they seal things, they strike things so the public never knows. It's true. Okay, go investigate 22CV003620 of Karen Phipps asked too, where she overruled actually what a black judge, because they don't like blacks, at the lower court, Franklin County Municipal Court in 1 CV02711, Honorable Judge James Green, black judge. All right. He heard a case and he dismissed my counterclaim without prejudice and told me to go over to common pleas and refile so it could be adjudicated on its merit. But again, what happened? Karen Phipps did just like Chris Brown. They spin narratives. They create their own half truth of a reality for themselves. It's actually an illusion and delusion. All right, for themselves. They spin it to where it looks good in their own best interest. And then they go and they use their legal expertise and knowledge and legalese and everything, go find case law, and then they try to substantiate their version of the facts, but they know the true material facts. They know the whole truth and nothing but the truth, but they want to tell you have truth and have you believe it, and you will because it looks good on paper, right? But if you know the underlying material facts and you know the details, that's what material facts are, you will never find in their favor. And you say, what the fuck just happened? And you'll hold them accountable. So that's why they revoke your rights. They take everything away. They take your voice. They take your 14th Amendment right. All right. They take your due process away. They don't give you the opportunity that's afforded to you innately, okay, inalienable rights, okay, to go in the court and have and not be judged, okay, and not face bias and prejudice and things like that. Yeah, they don't. They don't want you to know, okay, and so they take your rights and shit like that. That's Karen Phipps, she did it, and also Chris Brown, okay, boo, yeah. All right, so anybody doing a true investigation will see it. I mean, it's actually clear, but I just want to know where the fuck's my money at, Brian Spitz, okay. But anyways, here go to reply. Now comes appellant. All right, pursuant to APP .R.18a. Yeah, I just really want to let the court know, right? So may the court recognize that the appellant, Brian Spitz, all right, he had not served me properly with his brief. I don't have a copy of it yet. And that's deliberate as well, because you only have 10 days post the actual service to reply. And he's hoping that I wouldn't reply or whatever, and that's why he doesn't want me to have a copy because I don't have it yet. But luckily, in the e-filing system with Ohio 10th, Ohio Court of Appeals 10th District, you know, they once something is filed, you get the notice, but that's not service, right? So I have the notice, so I was actually able to go into the portal itself and then look it up and see what it said. Right. So I just went on to put my reply in. So basically I said, listen, these people, they continue to posit misrepresentation of fact related to the totality of the circumstances grounded in material tribal facts known to all parties in this instance. Right. Several fishbones to this matter exist relative to, you know, what I outlined already in my assignments of error, which require adjudication on merit as a matter of law for these reasons, inclusive of not limited to it. Just because I left something out because I don't know, I'm not a fucking attorney. Right. The grand theft of property, deprivation of constitutional rights, frivolous conduct, malpractice, breach of fiduciary duty, right? Okay, they never safeguarded my property that they actually seized without implied or express consent. Aetna Resources LLC, CVS Health, CVS Pharmacy. I don't know who it was now. I mean, I don't even know who's who in this shit, but I do know that their counsel, Lintner Middleton PC, was at the forefront, and they actually do have a duty to their client to ensure that they do the right thing. So yeah, they seized my property, for this piece of shit in a pleader, knowing there was no charging lien or any lien that had attached to anything of mine, and that Spitz is just a creditor, right? Asserting an indebtedness. They had no consent. Richard Diageo, he sent me an email asking for my consent. I told him fucking no. He kept harassing me time and time again. And I said, no, you're putting me under stress. So please just leave me alone and just do what the shit said, the agreement, and leave me alone. Like, I'm so sick of these people. These are bad people. They keep bothering harassing me. This is ridiculous. I mean, I said, you're causing my mental health diagnoses to be exacerbated by this. I mean, that's part of my disability claim, y'all. These people are retaliating. They're causing me these issues on purpose. So anyways, they stole my money, and the least they could have done was put it in a safe place, right? No, they didn't. So when you do that in a pleader, there needs to be a separate account, a fund created, and you need to put the money in that as separate from your own revenue. But at the end of the day, what we do know now is that CVS Health Pharmacy actually issued my $15,028 to Spitz Law Firm, right? So that tells you right there, it was still a part of the revenue of CVS Health, Aetna Resources LLC lead company, which is a part of all of their revenue. And you know, you can't do that. It has to be in an interest-bearing trust account, escrow, court registry, IOLTA, or something with a fiduciary title set aside with its own separate identity. It has to, all right? And if you fail to do that, that's a breach of fiduciary duties. It's actually just theft point blank, period. We know it's theft already, but I mean, this just even more so drives home my point. All right, why these bitches keep fucking playing with me, I don't know. Why they're not arrested, I really don't know. Why my fucking $15,028 has not been sent to me, I don't know. All right. So then also you got breach of contracts, existence, and disregard for the federal law grounded Title V11 Civil Rights Act of 1964, U.S. Equal Employment Opportunity Commission EEOC settlement agreement, which is 532-2022-02705. All right. Salvador Lopez was the mediator in that, right? That occurred on October 14th of 2022. The agreement was signed on October 18th of 2022. There is a final MSA agreement because the initial agreements actually had to be voided, and because Salvador and Richard got together and they were cahooting and all this type of shit to get Spitz Law Firm $15,000, okay? But then they voided them their own free will, right? Because they know there's no lien and all that shit, don't have to keep going into it. But anyways, so that particular agreement needs to be interpreted, okay? What is that noise? It needs to be interpreted relative to its terms, okay? So basically, and stating in here, grievance to reverse. So basically, this court, I'm asking to reverse and vacate the summary judgment, right? All right, so then I go in to just say, listen, a contingency contract existed between myself and Spitz pretty much. And Spitz, they just keep on fucking talking about the contingency fee and how it's clearly stated in the contract. Well, yeah, it is, okay? What? I mean, you breached the contract, so, okay, what is that? That has nothing to do with nothing. The contingency fee itself is not that's what's at issue. What's at issue is whether Spitz Law Firm is entitled to the fee, all right, and the reasonableness of their fee that they're trying to charge, okay? So basically, I just say, listen, Spitz, or their appellees, they maintain that the contract also states that the contingency fee is fully earned upon Spitz selling the case above Clark's authority. Okay, they did not settle any case. They claimed that they settled a case. Okay. That's not the case that was actually settled. They claimed that they settled my federal case. I don't know what the fuck they're claiming they settled, but they did not settle the EEOC MSA settlement case. All right. They were not there at the mediation. They were fired. They withdrew. They contributed no work whatsoever to the EEOC settlement agreement at all. They actually contributed no work whatsoever to whatever settlement they're talking about that they got 37.5 for. All right. Okay. They did not. If they did, then okay, come and prove it. But they don't have a signature on any type of settlement or nothing like that, honey. All right. They don't have no work. They don't have no motions, no pleadings, no research, no litigation on research, no nothing. They ain't do no deposition. They ain't called nobody on no phone. They didn't do jack smack shit. They're utilizing that settlement authority as their way to strong arm people into these fucking piece of shit settlements that they're really not even communicating with people. They're not doing anything. I don't know what they're doing. What are y'all negotiating when you're not getting back with the people and asking them or telling them what the other side is saying so they can rebut or refute? These people are weird. These people are menaces. How many other people have they done this to? If this law firm has done this to you, you literally need to come out and speak up and speak out so we can get a class action going on their ass, because this makes no sense. This settlement authority agreement still does not give you the right to just take complete charge over somebody's life and revoke their right to have the involvement and make a decision. You can't do that. That's ridiculous. And if you find out that somebody's doing it, which I did, it's misconduct. It is. I'm like, no, this is a scam. I'm not going to settle for no shit like that. I haven't even heard from y'all motherfuckers. These people are liars. Okay. So anyways, they withdrew from my case with the federal case. And then they also sent a letter to Richard Diageo saying that April Clark is going to go through with her mediation. I already had my mediation scheduled before I hired Spitz, okay? I didn't schedule it. EEOC schedules their own mediations. No attorney or anybody else can call in and schedule mediation. That's something that the EEOC mediator sets up because he has to outreach the respondent and see if they're willing to participate. Then he has to outreach the charging party and see if they're willing to participate. And then he schedules it. All right, so that was already scheduled prior to July 19th of 2022, okay? Now, if anybody had any question of that, couldn't Salvador Lopez, mediator with EEOC, be brought in? Couldn't an expert or somebody else from EEOC with the information with respect to how the mediation scheduling process works, couldn't they be called in to speak to that? To further demonstrate as evidence that Trisha Breedlove of Spitz Law Firm did not schedule an EEOC meeting or mediation or nothing? Yes. Okay. And in fact, Nick Kerr, they said that I had spoken with Nick Kerr, worked with Nick Kerr. Well, what that means is I did speak with Nick Kerr. That was the person that I spoke with for the free consultation. And that's the extent that I spoke with him, and never ever again. And I sent all my pro se work over to him. I spoke to Greg Schumacher one time when he told me he was sending a demand for settlement letter to CBS, Littner Mendelsohn, and whoever the fuck. I never heard again from him ever. Okay. And that was in July. So they were hired July 19th, 2022. I spoke to Greg Schumacher like July 24th, 2022. I didn't talk to anybody else ever again until September the 13th of 2022. And that was by way of email, which was Trisha Breedlove outreaching, asking about employment status. And I specifically told her then, I don't know who you are. I never met nor spoke with you before. I don't know anything about what's going on. Then she told me she was negotiating. So in their appeal, they say like, yes, I acknowledge that they was negotiating. Well, that's what you told me. So I said, yeah, okay, so I know you're negotiating XYZ, but I need more information. Like, now, how is this fee? Like, how are you splitting this up? And what exactly is going on? And then I got to thinking, something is not right here. This is a scam. How are they able to do that? I don't have to accept anything, and I never have to say so. And this doesn't make no sense. And I said, you know what? That's what they're doing. This is illegal. They have this authority settlement thing in place so that they can do these settlements in their own best interest, and then use that as, well, they knew what they were doing. They should have said back then and shit like that. That is bullshit. So you need to come into court and prove the work that you did. All right. I'm not saying that you can't get paid, but you need to get paid for the services that you actually rendered that equates to your professionalism and your level of expertise and education that you did in my best interest and on my behalf. You can't do work on your own behalf and expect to get paid for it. So you come into court and let somebody look at things objectively and make a determination and then fairly do what they need to do, just like they would in any creditor situation, like creditor debt type situation. All right. So anyhow, I said Appellee Spitz has not earned the contingency fee it claims and has no actual work to demonstrate otherwise. That's true. Spitz claims a lien against recovery of a settlement judgment, or otherwise for payment of any fees and or costs under contingency contract. Yes, Spitz has no lien that it has provided notice nor perfected any court, which attaches to the EEOC settlement. And in this, and was known. That's what I'd say. And this is and was known by all parties to this instance prior to the founding of the interpleader, right? In the trial court. That's true. Everybody knows there's no lien. Everybody knows exactly what happened. I didn't lie about anything to anybody. Everybody knows about the dispute. Everybody knows everything. So Spitz says, well, they have lien rights. And so because they have lien rights, they could put a temporary restraining order on any of my settlement monies or whatever the fuck. There's no lien rights because no lien exists. So whatever you're arguing relative to a lien is moot. It makes no sense whatsoever. There's no restraining order, nothing else, because you don't have a lien that afforded you any right. All right. So it just makes perfect sense. I mean, these people are stupid and these are lawyers. I don't know who's going to give me my honorary attorney my law shit. Okay, what the fuck? I mean, this is ridiculous. Okay, so Appellee Spitz did not perform work pursuant to the contract and did not represent, litigate, contribute to, or recover any of the settlement funds on which were ultimately misappropriated, willfully, deliberately, and with malicious attempt to continue to harm, injure, and victimize me, right? So Spitz did not collectively or individually spend any time or hours on Clark's claims, that's me, from higher determination and have no evidence to prove otherwise. Hence the conspiracy to collude with Littner Middleton PC and trial court presiding Judge Chris Brown to ensure Appellee 14th Amendment U.S. and constitutional rights specific to judicial access and process were revoked and deprived in efforts to silence Appellee and hide existence of misconduct of the judicial system and its elected officials and agents. Okay. Yeah. I'm not lying about anything. Everything's true and accurate. Okay. It's not libel, it's not slander, it's not defamation, not shit. It's all true. I have receipts. They don't want you to see the receipts, but I have it. Yeah, they know it. Spitz law firm has no integrity and continues to present to every court with unclean hands. These acts are egregious. Spitz did not file any employment claims or charges, perform pre-litigation research, discovery, evidentiary work, deposition, file or any motions, pleadings, or briefs in any of my claims or charges and cannot prove otherwise. Spitz does not have any fronted costs associated with any of my claims or charges and cannot prove otherwise. Spitz did not represent Clark in any of the investigations of the claims or charges and cannot prove otherwise. Spitz did not mitigate or litigate any of Clark's claims or charges and cannot prove otherwise. Spitz did not schedule mediation with the schedule, which was scheduled by EEOC on or about July 2022 prior to the hire date of Spitz. Spitz law firm did not schedule the mediation. Salvador Lopez EEOC did. In fact, in the Kerr of Spitz law firm and for appellant, he was unsure if Spitz could represent an EEOC ADR as appellant had already filed the charge and begun the process when Spitz law firm, because he said Spitz law firm usually does that for our clients. That's what he said. Okay, but I had already done it. Okay, Spitz hasn't done shit, and they looked at that as an opportunity to jump on board and say, "Fuck, shit, she already did everything. We're about to just figure out a way to get us a couple $1,000s for not doing shit. Just kick back and just picking our butt and twirling our pubes and looking at each other and saying, hey, we hate blacks. Fuck her. Look at what this black girl just did. She about to get us $15,028. Yes, look what our slave did. Yes, she did. We are slave masters. Woo woo." So Spitz never once presented, represented, mitigated, or actually litigated the U.S. District 7th Division 2:22 CV02519. Trisha Breedlove merely filed a motion to appear and motion to withdraw, never filed the claim or paid any court filing or associated costs. Also, Spitz did not file Clark's EEOC charges or House Civil Rights Commission or OSHA whistleblower retaliation charge and never spoke to the investigators in those matters as representation. Spitz never uploaded or provided any evidence via EEOC portal, online court CF filing system portals in any of Clark's employment claims or charges and cannot prove otherwise. Spitz law Tricia Breedlove claims to have negotiated settlement on Clark's behalf, yet Richard Diageo of Littner Mendelsohn admitted in EEOC mediation hearing held October 14, 2022, that he was unable to reach Tricia Breedlove and abandoned negotiations Spitz claims to have been participating in the best interest of Clark. Spitz has no evidence of any response to Aetna's filed motion to dismiss and compel arbitration against Clark, and none is reflected on the case record of Title V11 Civil Rights Act of 1964. Appellant Clark filed pro se prior to hire of Spitz Law Firm, Federal Employment Claim, U.S. District Southern Division 2, colon 22 CV 0215 519. Spitz Law Firm continues to present to this court as the trial court, I'm going to say as the trial court with unclean hands, spun narrative and half truth, knowing full truth related to material tribal facts as a matter of law. Spitz relies on the written settlement authority and authorization, attempts to utilize it as grounds to hide not actually performing under the contractual agreement, but actually committing malpractice and negligence, hoping their legal knowledge, expertise, and legalese, I spelled that wrong, will disguise their unethical practices to any higher court of individual that finds interest in this matter, which is outrageous. Some ice. Oh, okay. I'm not on video, so you can easily walk by. This is my voice. Yeah, it's just a voice. Okay, so Spitz did not work to settle claims in best interest of Clark, and once the ill will and want of tax tactics and strategy of Spitz Law to work on its own best interest. Versus that of Clark attorneys was revealed to Clark, not exercise the right to no longer continue with the attorney-client relationship. Clark gained insight into the reality of the practices and intent of Spitz Law, which was to ultimately gain from the fruits of Clark's per se labor, blood, sweat, and tears, in addition to her fronted costs and expenses relative to her own discovery, evidentiary work, investigation, pre-litigation research, court claim charges, filings, including motions, pleadings, and briefs, as well as letter drafting and mailing, copy scans, uploads to portals, interviews, and discussions related to charges and claims, etc., in every single instance in her own employment claims and charges. Once the fruits of Clark's pro se labor was obtained, Spitz Law Firm willfully, deliberately, and intentionally with volition set out to deceive and represent material facts to paint a colorful picture in its own best light, as it appears to be routine for Spitz Law. Okay, Spitz could not argue merits of case in any so-called negotiations, as Spitz was not in regular communication with Clark, and to date, Clark has no insight into what Aetna CVS noted relative to the demand letter for settlement grade Schumacher. Spitz claimed he sent, nor any rebuttal or refute by CVS Aetna relative to the demand letter. Okay, Clark has no insight into any argument CVS Aetna offered during any so-called negotiations with Spitz Law overall, or Tricia Breedlove at CVS Aetna would have no argument. Clark has and never had any poor performance reviews, appraisals, or policy violations as an employee of CVS Health as a nurse care manager ever in the tenure of employment, and no party can or will demonstrate otherwise. Hence, the Ohio Department of Job and Family Services termination without cause and allowed unemployment benefits post-termination during participation in so-called protected employment discrimination activities. Clark maintains the right to fire Spitz at any point of hire where misconduct is discovered, revealed, or discerned. Spitz Law Firm tricked Clark and attempted to get off scot-free by way of presenting the contract it breached and settlement authority it uses to abuse, neglect clients such as Clark. If Spitz Law has actual work, there should be no complication in demonstrating such in a court of law consisting of jurors that are non-biased, non-prejudicial, and have ability to act impartially, where trial court judge Chris Brown cannot. Okay, Spitz Law is not and was not entitled to Clark's equitable property in total and entire sum $15,028, which was seized without implied or express consent by Littner Mendelsohn PC, Aetna Resources LLC, CVS Health Corporation, CVS Health Pharmacy Inc., Cleveland, Ohio Attorney Alex Fronder, New Jersey Attorney Richard Diageo, in conspiracy to commit grand theft money heist scheme. An improper interpleader was filed by Alex Fronder, counsel for Appellee Aetna Resources LLC, willfully and with deliberate intent to misrepresent material facts of law, thinking his legal expertise and knowledge would mask the crime. Spitz Law is a participant as a vexatious, or how do you say it, vexatious litigator in the misappropriation of Clark's equitable property known to rightfully belong to her by way of the legally binding and enforceable EEOC MSA and general release conditions and terms, which clearly illustrates all funds due in confidential settlement, including the $15,000 are payable to charging party in full, total, and entire sum directly. It does say that. Spitz is a mere creditor asserting indebtedness. No lien attachment to the equitable property of Clark exists, yet Spitz was paid directly from alleged tortfeasor Aetna Resources LLC, lead company under CVS Health Corporation, CVS Health Pharmacy, a remittance advice in the amount of $15,028. CVS Health Corporation, CVS Health Pharmacy Inc., nor Aetna Research LLC has direct obligation to Spitz Law, granting legal grounds for right to issue the equitable property of Clark to Spitz Law. No fund exists for the imaginary lien Spitz Law claims, and clear breach of fiduciary duty exists, and does the crime of grand theft, in which continues to be covered up in attempt to further harm appellant Clark and victimize her as a Black woman who filed several employment claims and charges grounded in Title V11 Civil Rights Act of 1964, race and disability discrimination, as well as EEOC, Ohio Civil Rights, and OSHA whistleblower retaliation charges. Appellant foresees this matter moving to the highest court and intends to file federal claims against each and every party to this matter and those with awareness of the felony of grand theft of Clark's equitable property, in which these vexatious or whatever litigators know and have participated, that has taken place and failed to report. Spitz Law provided the following argument and case law, which applies to appellant argument as well. So I use law as their own. Shit, this is what they're basically saying about malpractice and what it refers to, professional conduct, failure to render services, that blah, 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 commensurate to their skill set, basically is what they're saying. Yeah, and that's true. Okay, right. Thank you for that argument, because in this instance, a malpractice claim existed against Spitz Law Firm, where trial court judge Chris Brown deprived appellant right to pursue in harsh and drastic ruling of summary judgment in favor of Spitz Law Firm, revoking human, civil, U.S., and Ohio constitutional rights, where the life, liberty, property, and pursuit of happiness of appellants was willfully, intentionally, deliberately seized under the color of law. Okay, Spitz goes on to note, this is where they talk about malpractice and what it consists of and the elements that you must have. Okay, so basically I'm saying in this instant, an attorney-client relationship existed. Yes, it did. Okay, in which Spitz, they failed to perform. Okay, in the best interest of Clark, me, as it specifically relates to professional duty arising from that relationship. They did not do what the fuck they were supposed to do as outlined in that fucking contract in the attorney-client relationship. Okay, it's not hard to see. All right, so therefore, by them not doing that, they breached their duty. And as a direct result of the willful and intentional actions of Spitz and its attorneys, I have been severely harmed and injured, and victimization continues to date, where clearly Spitz Law is not and was not entitled to a trial court harsh and drastic summary judgment ruling by Chris Brown, who ignored all motions and pleadings and like, okay, I don't give a fuck if that ain't the grammar. I don't care. You know what I'm saying? I don't care. Okay, I don't give a fuck. In fact, trial court Chris Brown deprived appellant of the right to be heard in a court of law where material triable facts were known to exist. Therefore, appellant has no opportunity to call, confront, or cross-examine any witness, despite a witness disclosure list being filed and reflected on a case record, let alone an expert witness. So what the fuck y'all talking about? Okay, Spitz. Yeah, they also said this bullshit. This is the shit that they talking about. Where you have to have some expert testimony. Okay, well, I got a malpractice claim. I wasn't able to pursue it because of what Chris Brown did. So how am I able to have an expert come in and testify on any fucking thing when I can't even have a day in court without my rights being revoked? Okay. Anyway, so as previously noted, a malpractice claim did exist against Spitz, where this judge deprived my rights to pursue and get that harsh summary. All right, you revoked all my fucking rights. Okay, I'm getting sick and tired of talking about it. All right, so basically, and I got sick and tired of writing it because it's beating a dead horse, like I said. And y'all don't get the point now, judges and all y'all people out here that's butt fucking each other. I don't know. I don't care. I don't own nobody's shit. I'm not owned by anybody. I'm not nobody's slave. These are nothing but mere people out here revoking rights, okay? And damn sure I'm revoking it of Black people. And you need to have Chris Brown investigated. You need to have Karen Phipps investigated. If you have a case out there where a summary judgment came about, or you weren't given the opportunity to exercise your rights, okay? Bring class actions. I don't fucking know. And give me a call. I'll be a witness, honey. Use this shit. It's on the court record shit to now, okay? Overall, in beating a dead horse and explanation, Spitz Law Firm did not act in the best interest of April Clark and did not render services in the practice of a profession to exercise the degree of skill and learning normally applied by members of that profession in similar circumstances. Spitz Law has no actual work and reviewing over 200 documents. A pro se work product does not constitute utilization of skill and learning normally applied by lawyers that warrants a payment of $50,000 to 28, nor does claimant to have negotiated a settlement on behalf of Clark using a settlement authority agreement to actually act in one's own best interest, okay, which is in violation of contingent contract and contract law in general. No lien that attaches to any settlement or judgment exists at all, and certainly not to any settlements Spitz Law Firm or any of its litigators negotiated, contributed to, mitigated, litigated, or represented, nor performed any actual work of its own. It can demonstrate in any court of law, hence Spitz participation in cahoots with Littner Mendelsohn PC, counsel for CVS Health Corporation, and all its subsidiary companies and its counsel and trial court, Columbus, Ohio, Franklin County Court of Common Pleas, trial court, Judge Christopher Brown, conspiracy to commit grand theft of appellant Clark of equitable property. Case law is clear and evident relative to the handling, mishandling of equitable property and fund safeguarding, as well as frivolous claim filings, malpractice, negligence, breach of contract, breach of fiduciary duty, misrepresentation, theft of property, misappropriation of funds, deprivation of rights under color of law, misuse and fraud on the court, and assertion of attorney or charging liens, establishment of interest-bearing trust accounts, escrow, court registry deposit, and all associated notices, approaches, and practices by way or procedural protocol or legally grounded guideline and standards, which would take a lifetime to outline in this reply. Okay, I got time to go through all of that. Y'all know, y'all lawyers, I'm not. The evidence is obvious in this instance that the matter warrants reversal, remand, and adjudication on merit. No matter how the appellee Spitz Law continues to insist it had legal right to the full, entire, and total sum of the equitable property, tortfeasor and the Resources LLC hid by way of remittance advice payment under another company, CVS Health Pharmacy Inc., to pay creditors Spitz Law for unauthorized debited income from appellant April Clark. In the meantime, the misappropriated equitable property stolen for April Clark should be immediately released by Spitz Law Firm, as it is and continues to be in receipt of stolen income from appellant in which it has no authorization or legal grounds as a mere creditor asserting indebtedness to have in its possession by any means. The crime is known and understood by all parties, and appellant intends to prosecute. Continuing to lie in court utilizing legal knowledge, expertise, and legalese to cover a crime is no defense to participation and continuance. For the above reasons, as well as set forth in the original brief, appellant respectfully asks this court to reverse and vacate the summary judgment entered by the trial court and report felony, okay, under any mandatory reporting requirements officials of the judicial have duty. Yeah, so y'all need to do that shit. Okay, boom, there you go.